And the reason being, sir, can I please have an explanation why?
Because you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up a fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker. But however, you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond. Mr. McCoy is here today. I've revoked his release based on his new charge. He held without bond on that. What else do we have? Mr. McCoy is here today. I've revoked his release based on his new charge. He held without bond on that. What else do we have? And Mr. McCoy, you understand that you're representing yourself. I have found you competent to represent yourself. At any point in time, these proceedings, you can ask an attorney if he appointed to represent you.
Yes, sir.
Do you still wish to represent yourself?
Yes, sir.
Okay. All right. It looks like there's been some, there's been a DCA case filed. I don't know if it's based on the discovery request or not. I don't know. All right. Yes, that's what it looks like. All right. Anything else today?
No, Your Honor.
All right. Yes, sir.
Yes, sir. Well, first, I would just like to request to have my bond reinstated, sir.
Motion denied.
And the reason being, sir, can I please have an explanation why?
Because you were out on bond, you picked up another charge, you pled to that charge.
And the only reason, sir, regardless of the facts, the only reason I accepted that charge is because they said they was only going to give me a fine. But the person that actually, was in the fight, they came there and they seen that I was breaking up a fight.
Mr. McCoy, I've already made my decision when you entered.
I understand that, Mr. Clark. I'm just stating this for the record.
You've set the motion that you were breaking up a fight and that you didn't cause a fight and you weren't involved in the fight, that you were the peacemaker. But however, you did enter a plea, and that's all part of the record. I understand that, but I am going to deny your motion to reinstate the bond.
All right, Mr. Clark. Can we discuss my case? I was here for a court date on my case.
Well, you've already filed a notice of appeal on the second request for discovery, so I don't know what else there is to discuss today.
Well, and then I was wanting to discuss, sir, is the fact that, my subpoenas and everything never got responded to. I filed subpoenas through the court and to the people about my the videos of my evidence, sir.
Well, if they've been served with subpoenas and they haven't responded, you need to do a motion for show cause.
Motion to show cause.
Yes, sir.
Okay. What about, I just want to know your opinion, sir, since you're the judge.
I can't give you my opinion.
No. Based on the proceedings, sir. That's with Mr. Frank Sullivan. It's not, I'm not looking for help. All the thing I'm asking, sir, is why am I been denied my evidence?
I don't know, sir.
Okay, if Bay County officers was the primary officer, sir, in my case. Okay. And they will only be an assistant.
I've heard this argument for the ever since you've been arrested. So it's already part of the record. I've already made my ruling. You've already appealed that ruling. So we'll see what the first DCA says. I'm going to set this for a pretrial June 19th at 9:00. That'll conclude the hearing.
To the court and to the people about my the videos.
The judge gave him space, explained the ruling, and closed it.
Can we discuss?
Instead of stopping, he keeps pushing. That never helps. Once a judge says, "I've already ruled," the conversation is over. Everything after that just burns credibility. You can hear the patience spinning. This isn't about fairness anymore. It's about control of the courtroom.
Well,
right now, he's losing ground fast.
And everything.
Okay.
Well, sir, I still had a couple things I really wanted to say for the record.
Say them on the 19th.
Seriously, come on, Mr. Clark, man.
What do you want to put on the record? I'm going to give you a minute. Go.
All right. The whole thing I want to put on the record, Mr. Clark, is I want to know what kind of beef that you got with me, sir, or Mr. Frank Sullivan, but I keep having multiple prosecutors filing motions against me, the ones that was pulled off of my case, and why they still filing motions against me.
I understand that argument.
But it makes no sense because it seems like my case is going nowhere, especially when you have nothing to even try to do.
These state attorneys don't stay here very long. The ones that are on your case are in another division. I have nothing to do with that. Mr. Sullivan has nothing to do with that.
He just said he does.
Huh?
He just said he did.
No, what I said, Mr. McCoy said that despite who the prosecutor is, you're also involved in my case. And I said, yes, that is true because I'm the division chief.
He's
I didn't say I had anything to do with moving prosecutors or changing.
he doesn't move, but he is the division chief. So
okay, if my old prosecutor's already moved to a different division, whatever, why is she still filing motions against me? And then obviously when she signed it, she said this motion is for Frank Sullivan.
They all sign it for Larry Bassford. It doesn't matter who signs it, who files it. They're filing on behalf of Larry Bassford. So that's going to conclude today's hearing.
That makes no sense, Mr. Clark.
Mr. McCoy, that concludes the hearing. I understand. There's nothing else to be said about that. Ms. Beasley?
Judge, Mr. Williams is before you this morning on his request to discharge counsel. He's also trial management this afternoon, but I'd ask that we take care of both these this morning.
Yes, sir, we will. Mr. Williams, you're asking to discharge Mr. Meredith?
Yes, sir.
All right, if you'll raise your right hand to be sworn.
Solemnly swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
Yeah.
All right, sir, lower your hand and state your name, please.
I'm Courtroom Williams.
All right, what's your basis to dismiss Mr. Meredith?
I don't feel like we had a solid bond as far as attorney and me.
Repeat that again, please.
I just don't feel like we had a solid bond formed.
Okay. You're gonna have to explain that to me, what a solid bond between your lawyer means.
Like, I don't feel like he was representing me properly.
All right, you're gonna have to give me some specifics.
Well, I asked him to do a couple things on my behalf, and those things weren't fulfilled.
Did he tell you why?
No.
Okay. What did you ask him to do?
Basically, file a few motions, present evidence into, present evidence on my behalf and
Present it to who?
to the prosecution.
Mr. Meredith, your response?
Your Honor, there was body cam in this case, which I reviewed. If I remember correctly, there's 3 officers. I negotiated a PTI agreement in which case all the charges would be dismissed if he completed the terms of that agreement. Yesterday from Mr. White, I received a misdemeanor offer in the alternative if he wanted to take some misdemeanors, but because of the status of him requesting a new attorney, I have not reviewed that with him. There's no motion to suppress based on what I've seen from the body cam. There is a potential motion to dismiss on the controlled substance, but I suspect the state would traverse that. Nevertheless, false name with adverse effect would still be there. And the state is willing to do the PTI, or now it's getting rid of the felony drug charge, reducing the false information with adverse effect to a misdemeanor, and allow them to do misdemeanor probation. There's no motions that I think could be filed.
That explanation hurt more than it helped. His own lawyer just laid it out clean. Body cam reviewed, offers negotiated, no suppression issues. That tells the court this case has been worked properly. When defense counsel says there's nothing that gets this dismissed, the judge listens. This isn't neglect. This is strategy, and it directly undercuts the argument for new counsel. From here on, the judge is deciding, not debating.
False name that would cause any charges to be dismissed. And if he doesn't want the offers from the state, we're scheduled for trial.
All right, Mr. Williams, I'm going to find that Mr. Meredith has been competent in his representation. I'm going to deny your motion to have another attorney appointed. You understand you've been offered a misdemeanor or a pretrial intervention.
Mhm.
I've dismissed all your pro se filing.
This ended exactly where it was heading. The judge kept authority the entire time. Clear
Offers from the
rulings,
state
clear boundaries. The defendant talked past the moment
Mr.
instead
Meredith
of
has
listening
been
to it.
competent to,
Self-representation didn't help him here.
to
It boxed
have
him in.
a
The
misdemeanor or
court
pretrial
denied
intervention.
bond, denied new counsel, and put the case right back
Dismissed.
on track toward
And
trial.
if he doesn't
Control
want
never
scheduled
left
for
the
trial.
bench. And once that
All right,
happens,
Mr.
there's
Williams,
no
I'm gonna
leverage
find his
left to recover in the
representation.
room.
I'm
Thanks
going
for
to deny
watching.
your motion.
Like,
Have
comment, and
another
subscribe
attorney
for more
appointed.
courtroom
You understand you've
reactions.
been offered based on your being represented. So, do you know what you wish to do today?
You asked me, do I know what I wish to do today?
You want to remain on the trial docket
Yes.
and face 2 felonies, or do you want to take a misdemeanor or go through the pretrial intervention program?
How long with probation?
It's up to a year on county probation. If locks in, there's no felonies. Do that.
All right, if you want to just have him have a seat, and you don't have to bring him back up, Mr. Meredith, just have him sign it and do an abstention. Mr. Meredith, tally
Your Honor,
for.
if I can call Mr. Williams back.
Mr. Williams?
Your Honor, Mr. Williams has an appointment at my office to watch the body cam this afternoon at 2:00 with Investigator Ryder. He knows that the state is revoking the misdemeanor offer, but we'd ask that it be taken off the trial docket for this.
Any objection?
I'm making a.
He's rejecting the misdemeanor, so.
Oh, yeah, sorry, yes, Your Honor. I have no objection to removing him from the trial docket, but that misdemeanor offer is revoked if he's not taking it.
Williams, you understand that? We'll set it, you want to set it for just a pretrial or a trial?
I'll defer to Mr. Meredith.
Either way, Judge. It looks like it's headed for trial, but I've tried to communicate with Mr. Williams.
And you're going to meet with him this afternoon and.
Yeah, the investigator will.
Oh, investigate. I mean, that's just as good. All right, just sign a note for that day, sir, and I'm going to take it off the trial docket.
Thank you, Judge.
So who's gonna be representing me? I'll be representing myself.
No, I'm representing you,
Okay.
but you're not going to meet with me this afternoon. You're going to meet with an investigator and watch it, and then you can schedule an appointment with him. Okay, just sign there. Judge, this afternoon, there's Jeremy Turner.
So is he withdrawing?
What?
He withdrawing to represent himself?
I don't know that
He didn't ever ask to represent himself.
he asked that I be removed.